Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about corrections and releases. Cases that should have gone to the Supreme Court of Canada, but didn't. Individuals who are sentenced to jail sentences in Canada are entitled to be released after a certain portion of their sentence has been served. And when they are released, they are on parole. And when they are on parole, they are subject to certain conditions, which are overseen by the Correctional Services. In circumstances where those individuals reoffend, corrections may take action to bring them back into custody, they may be charged with offenses, there are all sorts of things that can happen. But one thing that has rarely happened is that the individual who committed the offense is being sued alongside corrections. And essentially this was the case that the Supreme Court of Canada had to consider, whether or not corrections could be sued for releasing somebody on insufficient conditions to protect the public or to protect the individuals who were then caused harm by them, or by releasing them in the first place, essentially exercising the discretionary release or the statutory release provisions. And this case raises a very important issue because although it was dismissed on the basis of the fact that there's no causal link between corrections releasing somebody and imposing whatever conditions they think are appropriate and the harm that befell another person, there could be cases where there is that causal link. And having the Supreme Court of Canada articulate when corrections is negligent in releasing somebody on insufficient conditions is a very important issue, especially right now as there is a national dialogue going on around repeat violent offenders and the so-called catch and release judicial system that exists in this country, or doesn't exist in this country, but is alleged to exist in this country. The Supreme Court of Canada could have had the opportunity to at least give the public confidence that in circumstances where releases are being done inappropriately, there will be remedies available to people who are brought to harm by that. But by establishing what level of evidence and what evidence may be necessary to show a causal link between corrections releasing an individual and another person coming to harm. It's not outside the realm of possibilities imaginable that something could happen that leads to somebody being harmed where corrections is sufficiently negligent that they caused that harm. And the Supreme Court of Canada ought to have outlined that so that members of the public can have some comfort in knowing that there are options available to them should there be something that leads to their harm, and to maybe be a little bit more open to the idea that people are being released and recognize that if corrections can be sued for releasing people improperly, they are going to make more steps to ensure that they are following all of the necessary precautions before somebody is released from custody. This was an opportunity to engage in a national dialogue in a way that would have instilled confidence not only in our judicial system, but also in our corrections and release system. And unfortunately, the Supreme Court of Canada really missed that opportunity to participate in this dialogue in an effective way. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Pool Creative for putting together these videos. Please like, subscribe, and share with your friends.